Thank you very much. As my dear professor introduced me, my name is Šimović. I'm an associate professor at the Department of Family Law, Faculty of Law, University of Zagreb, Croatia. And today, together with my dear colleague, full professor Anica Margaletić, we will be talking about the child protection system in Croatia. Before moving on to the presentation, I would like to thank the organizers for having us, for calling us, and for organizing such an outstanding and very important conference. I would also congratulate the authors, the editors, and the publisher of the new book, Child Protection Systems, which I believe is the 5th book in the International and Comparative Child Rights series, so it is really an accomplishment. So I would like to start off the presentation with a brief introductory overview and the constitutional foundation of the Croatian child protection system. So the child protection system in Croatia reflects the spirit and the letter of fundamental principles that are prescribed within global and regional legal sources that are an integral part of the Croatian legal order. We are of course talking about the CRC, the European Convention on Human Rights and Fundamental Freedoms, and of course the Charter of Fundamental Rights of the EU, among others. Considering that our system, our child protection system, consists of several elements, and these are the legal system, the educational system, public finance system, healthcare system, and social welfare system. All these systems needed to be adjusted to the high standards of child protection that are prescribed within the aforementioned global and regional legal sources in order to form one functional and effective framework of the child protection system. I would also like to emphasize that in Croatia, the child protection system, as we call it academically, is publicly financed. It is approximately financed 65% by the central state, and the rest of 35% is financed by the local and regional self-government units, meaning the counties, municipalities, and cities. Turning on to the constitutional foundation, taking into consideration that the Constitution of the Republic of Croatia is the highest legal source in our legal order, I believe it's very important to emphasize that it guarantees protection of children and youth by the state. And in this regard, it means that the state is obliged to create social, cultural, educational, material, and other conditions in order to promote the right to a decent life of children, among others. We also believe that we needed to define in our report the role of the state. So on the one hand, the state needs to provide assistance and help the parents or the primary caregivers of children. And on the other hand, it has a duty to intervene more rigorously in the family life of parents and children when needed. So it's really not an easy task. In Croatia, the primary responsibility for the development, growth, upbringing, and protection of children lie primarily with the parents, as prescribed within the CRC and our Family Act. But if the parents do not have sufficient parental competences, then the state authorities have a duty to help them, to provide assistance to them in the exercise of the parental care and their rights and duties. However, sometimes parents cannot protect their children from inappropriate actions of third persons, and sometimes they themselves endanger the development and welfare of children with their actions or often omissions. In those situations, the state authorities have every right and legal ground for intervention. And the goal of such an intervention into the family life of children and parents is to first and foremost provide assistance to children, parents, and the family by imposing preventive measures, and on the other hand, by imposing repressive measures The goal is to protect children, but not to punish the parents. Regarding guiding principles of the child protection system, we will give a brief overview because they were also mentioned in the previous presentations. So we will, of course, start with the supreme legal standard prescribed in the CRC and our Family Act, and that is the principle of the primary protection of the best interest of the child, and the principle of the child to be informed and to be heard. Another very important principle of the Croatian child protection system is the principle of the non-discrimination, because our constitution, very similarly to the CRC, contains a provision stipulating the prohibition of discrimination against all persons, including children, regardless of their race, gender, religion, social origin, and etc. Of course, there is the principle of proportionality, which we will cover more thoroughly in the remaining part of the presentation. And last but not least, the principle of urgency. It is prescribed that in all family law proceedings regarding the child, the competent authorities must proceed with urgency. The logic behind such a provision is because if the proceedings are not carried out urgently, then there is a risk of the so-called de facto decision-making or the codification of the status quo, which is, of course, not in the best interest of the child. In the report, we wanted to define who is considered to be a child at risk and what is considered to be a necessary intervention by the state authorities. A child at risk, generally speaking, is any child whose rights, welfare, and development are either endangered or violated. Our Family Act prescribes that rights of the child are endangered if the care of the child is inadequate, or if the child has psychosocial difficulties, behavioral, emotional, educational problems, or if there is a likelihood that such problems will occur. Also, we summarize that children at risk are if they are without adequate parental care due to factual or legal circumstances. So, for example, if the parents are in prison, if the parents are hospitalized, if the parents are, for example, minors that cannot adequately take care of their children. A child at risk is also a child that does not receive maintenance either from their parents or the other maintenance subsidiary maintenance debtors. And if the child lives in poverty, meaning a family that does not have enough sources to meet the basic life needs. So, as said before, in all those situations, if the child is at risk, the state has the duty and obligation to intervene, but that intervention needs to be necessary. So this means that the purpose of the imposed measure could not be met by some other more lenient measure. This also means that the competent authorities determine the measure that least restricts the right of the parents to take care of their children, and that it is possible to protect the child with such a measure. So competent authorities have their hands full. Also very important to understand is that all measures which are imposed by the competent state authorities need to be based on an expert interdisciplinary evaluation of the family situation. And in this regard, two instruments assist professionals in the decision-making process. This is the Child Developmental Risk Assessment List and the Safety of the Child Assessment List. The last part of my presentation, and then I will give the floor to my colleague, is the financial instruments of our child protection system. The state prescribes tax benefits through the Value-Added Tax Act for certain groups of products and services that are primarily intended to meet the needs of children and their families. There is the Institute of Housing Support, so the Act on Subsidizing Housing Loans enables just that, subsidizing housing loans, for citizens not over 45 years of age who will use those funds for the purchase or reconstruction of their house or a flat in order to meet the basic living needs for themselves and members of their families. There is a demographic element to this instrument because it is reflected in the fact that the subsidized loan term is extended by 2 years for each child born or adopted during the subsidized period. Turning on to the classic family law institutes, and that's the Child Maintenance Institute and temporary maintenance, they have the goal of protecting the child's right to adequate standard of living as prescribed within the CRC and our Constitution, as is the Institute of Child Allowance that represents a monetary income provided to the parent or another caregiver, step-parent, grandparents, or whoever is providing care for the child, or with the goal of providing support to maintenance and upbringing of the child.